our bumper sticker was surgeons must confirm before they cut. Very simple. And the second rule is surgeons must give patients accurate and complete information.
She told her client, you 100% have cancer. Their only option is a mastectomy. Both of those things were lies.
Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
Welcome back to Just Verdicts. I'm your host, Brendan Lupetin, and today, happy to have with me attorneys Chris Wright and Anthony Laramore from Page Law down in St. Louis, Missouri, joining me today about a great, interesting med mal verdict you guys got about, how long ago? Was it a few months ago?
Yeah, November verdict was handed down Friday, November 23rd. Anthony, is that, or 20? Yes, no.
Yeah, the week before
21st. 21st.
Right before Thanksgiving. That's always nice, right? Going into a holiday and, get the W.
It is. It was very nice, very surprising because that venue is a really tough, traditionally very conservative venue. And Anthony and I have both tried cases there before, and we weren't very lucky in those cases. I think we had a perfect storm come together in this one.
Oh, that's awesome. And I was actually trying a case that week as well, like literally the same time you guys would have been. And mine, I guess, sort of fortunately settled right after openings. Whenever you settle, it always sort of like sellers or buyer's remorse. I'm not sure which one it is, but had a little bit of that until I remembered right before the break. I'm like, oh, this is sweet. The rest of my week is wide open now. So
right.
You guys were in there, fighting the real fight for that whole week. So anyway, before we get into the case, just love to hear a little bit about both of you guys. So Page Law, nice injury practice, med malpractice down in St. Louis. Chris, I know you from the ATLMG listserv that we're on. We've got some, ties of people we're friends with here in Pittsburgh, but yeah, just, tell me about your guys. How'd you guys get into, medical negligence? And I know you do personal injury as well, but, how'd you find your respective paths to this bizarre area of the law?
Yeah, so I'm gonna intro right into that. It was great because so I was taught and trained by two guys in actually more than that, but the whole firm in Kansas City called Bartimus Frickleton. Jim Bartimus and Jim Frickleton trained me. I was a second-year law student working with them. My very first major assignment was putting together a PowerPoint presentation for a really significant surgical malpractice case, actually in North Carolina, where a children's youth pastor at a church was in surgery getting a parotid gland tumor removed, and the North Carolina hospital surgical nurse was pregnant. And when they were about to fire the laser, when the doctor was going to fire the laser to remove the tumor, the pregnant nurse inadvertently bumped the laser, and the laser severed his middle cerebral artery, and he had a massive stroke. And so that was my first kind of taste of med mal, was going there with them and putting together the PowerPoint. And Jim Friggle and Jim Bartimus really taught and trained me how to become a med mal lawyer for the 7 years I was there. And I just fell in love with it. I was never a science or math guy in high school or college, poli-sci major. And Anthony can tell you that I'm not a very good math guy based on what happened in this case, but I just fell in love with it. I really loved Jim Bartimus and Jim Frickleton. I respected them, loved them, and just loved the way they practice law. And they really taught and trained me. And then other guys in that practice like Steve Gorney, Paul Kavanaugh, Kirk Presley, Peter Obetz. I just learned to love med mal and was really interested in it. I loved the back and forth. I loved the research that we had, as lawyers in med mal, we have to learn the medicine. And although we don't ever want to fight the doctor on the medicine, sometimes we got to know it. And sometimes we know it better than them because the docs, they know a lot after being out 20 years out of medical school, but we can really hammer them by knowing the guidelines and the literature and all that. And I just really enjoyed that aspect of it. And so, quite frankly, Brendan, I've tried to get out of it over the years because Missouri is just a really bad place for those cases. We've got horrible non-economic damage caps on them. There are other laws in the state that just are really designed to prevent lawyers like me and Anthony filing med mal suits against hospitals, nursing homes, and doctors. And I've tried to get out of it, and God knows why I haven't been able to, because people keep referring me cases and good cases. And so I just stuck with it, and I love it, and I love my clients. Generally, they're all good people who have just had really bad things happen to them, and I just feel like they need representation, and I just, for the life of me, can't get out of it. And so that's kind of how I got into it. And John Page took me on in March of 2020 when the pandemic was just starting, because my former law partner Brian Milliken, we were dissolving our firm because he wanted to go in house and do his thing and do something with the St. Louis Police Officers Association. And so I've been here since March of 2020 and love it. And I will take credit for getting Anthony in our firm, and I'm going to let Anthony then tell you about him.
Well, I'll just jump in there real quick, Chris, because I think probably maybe not all, but a lot of med mal lawyers, because it can be so challenging and tough, and then there's all the stigma that goes in with being a lawyer, that oh, the bad lawyers that sue doctors. But when you're coming back, I think at that Sopranos line, just when I thought I was out, they pull me back in. But
True, true.
but Anthony, so you know, so Chris is telling us, he's responsible for pulling you into the fold of the Page Law firm. So tell us a little bit about your background and history to get into MedMal.
Well, before joining Page Life, I'd known Chris for a really long time. We used to compare notes and talk about cases all the time. But I think getting into MedMal was just sort of an offshoot of my really strong desire to try cases. And, of course, on the civil personal injury, and that kind of big umbrella, I think it's certainly here in Missouri, if you want to try personal injury cases, medical malpractice is where you want to go to. And so I certainly have had an opportunity to try many of them. But I absolutely love being in trial. And like Chris said, these cases are very challenging from a trial lawyer's perspective because sometimes they can be so complicated. And I've always felt like that my skill, probably from having a dad that was a pastor for 35 years, honestly, but one of my skills was taking things that seemed to be pretty complicated and trying to boil them down to very simple terms. And so I felt like MedMal was a good place to have that kind of thought process. But like Chris said, I sort of got roped into it when a mother walked into my office 15 years ago, and her son was a victim of suicide. And when we started looking into that case, the jail was, he was in jail, but there was also a medical malpractice component to it. And when I started looking at that, I thought, well, this just can't be right, and someone needs to try to do something about it. And that was kind of the first case that involved medical malpractice that I took on. And then I was lucky enough to have a few great mentors and got to do some cases, GI and like misdiagnosis of heart attack, and kind of got thrown into it very early in my career and just loved it and ate it up. But it certainly is it's a difficult area of practice. There's no doubt about that.
Anthony, with your dad being a pastor, two questions. One, it sounds like that had a positive influence on sort of your interest to, I don't mean to simplify it so much as to say public speak, but to kind of communicate messages to groups of people. Was that the case for you as a kid growing up?
Oh, certainly. I've known me and my wife met in her sophomore and my junior year of college, so we've been together for quite some time. And my wife has always commented that, you know, I've never had any fear or trepidation about speaking in public, but that was because when I was a kid, I grew up in a small country church, and we were up in front of the church all the time from the time we were little kids all the way up until we were teenagers. So it's just, having that experience, speaking in front of groups never really gave me any fear. I think like maybe it does some people. The ironic thing though is my dad used to preach and he would close his eyes when he would minister. And when I was a kid, I thought my dad was just the world's best, kind of a multitasker. I thought he was praying and preaching at the same time, and I thought, man, that's really something that he can do that. But he did. I didn't have the really, I guess, the bravery to ask him until I was probably 16 or 17 why that he closes his eyes when he preached, and it was because my dad was scared to death to talk in front of large groups of people.
Oh, wow.
Yeah, so
Funny.
kind of ironic.
Yeah, no,
Brendan,
absolutely.
Anthony is not scared to death to talk in front of large groups of people. He actually he's really downplaying it because his experience with his pop clearly has driven him to do what he's doing. And I mean, I will tell you in our case, and because closing, we split up closing. I started and he did rebuttal to kind of shove whatever the defense black hat said right up their keister without having somebody being able to respond to it. And he actually used a really great story from his experience and life experience with his dad, and it really kind of fit. And Jim Reinert, the defense attorney, kind of walked right into it in what he was saying in his closing. And but Anthony's experience, Anthony just has so many good experiences, and I'll call them popisms because that's what I call them with my pop, that and life lessons that we can use, and he uses them great, and he used it in our closing in our case, and it really, I think, helped brought everything home with the jury. Anthony, you want to tell them about that?
Yeah, I mean, I really think that one of the hardest things that jurors have to contend with in medical cases, and you can certainly understand it. One is I think they go in generally with the attitude that they want to trust their doctors, and I'll be the first to tell you, I think most medical professionals are good people that are trying to do the right things. And my sister's a nurse practitioner, for instance, and she just is a good-hearted person, but at the same time, whenever you go into a medical malpractice case, they have that in their mind as they want to trust their doctors generally. But then secondly, all the medicine is so confusing. Like I said, I mean, I feel like I sort of can sympathize because when I first started doing medical malpractice, I was like, what does this mean? What is that? You having to Google words all the time and things like that. But, so it's just, the story that Chris was talking about, it was just something about when my dad told me when I was a kid, and now granted, we know most of this venue, most of the people on our jury are religious folks, like they're church going people. And like, you have to know that background, like you've got to kind of, and like I said, I mean, I would never do this if it wasn't like authentically me. I think it's really important to be yourself. But I told a story about when I was a young man and my dad handed me the Bible, and I said, well, Dad, some of this stuff is just so incredibly confusing, and he said, well, son, the way that you can filter through and make good sense of all this is just to remember the guidepost, and that's Jesus loves you, do right, and when you mess up, fess up. And I told him that, and I said, in this case, it seems like there's so much confusion, and you've heard all these doctors testify in this medicine, these articles. You might wonder, how can you make sense of all this? It's like, you just have to remember the guidepost. And in our case, that guidepost was our rules, and, you got to confirm before you cut and things like that. And I thought it went pretty well, but then I just got to talk about how the doctor was a liar, and it was terrible. So Chris gave me the really fun part, and he probably would have done a much better job with it than I did, but it was
No
really
way, no way, no way. I what I learned from Jim Barnabas and Jim Frickleton was recognizing your strengths and your weaknesses. And, it doesn't matter who does what in these trials, as long as it's for the betterment of the client. And is it going to get the client the best result possible? And
absolutely.
I recognized pretty early on, Anthony jumped into this case, a month before trial, and I've been litigating it for 10 years. And if he hadn't done that, we would not have won the case. If he hadn't done that and helped me try it, I could never have tried that case alone. And that's the one thing I've learned and I counted it up after this trial. I've been first chair or second chair in 16 med mal trials over the years. And I just, in the middle of that trial, I kind of, or towards the beginning of it, I said to Anthony, you're going to do the rebuttal closing. We're going to split it up because I really think that you will do a great job at that, way better than I would. I will do a good job of reminding them of who our expert was, what he said, and do a good job of those things and bringing them back to what we talked about, because that's one of the things that defendants benefit from. That's why they have so many experts in these cases. They want the jury to forget our great expert who may have gone 2 or 3 days earlier, and they forget it. They forget him or her. And so I always think the very first thing we need to do, or I need to do in closing, is remind them of the guideposts, the rules, right? And then bring them back to and show them our doctor, in our case was Dr. Ash, and how credible he was, how great he was, how simple it was. He was talking about what the standard of care was, and how the other doctors didn't even touch his opinions. And so I'm great at that. And I think I did a good job at that. I could have done better, but Anthony just really kind of came in his rebuttal closing and just drove like 7 nails in the Benris's coffin. And it was just amazing. And so I appreciated Anthony for that. I just have learned, I think we do our clients a disservice when we try these cases alone, to be honest with you, because one, I think it's too much for one lawyer to try and handle competently and really at a high level. It also, I don't think, is good for the lawyer's mental health. But I also think it's good, just like when you do focus groups or when we do our attorney roundtables and go through cases and try to figure out what the rules are, what the bumper sticker is, whatever. We need more eyes and ears on these cases so that it helps us be better in our story, in our approach, what not to say, what to say. And I thank God for Anthony coming on and being here and jumping in and doing as good as. But his closing, he put nails in the coffin. And what was great about it was me getting to watch. I'd look at Anthony doing his thing in the jury, and then I'd look at Jim Reinert and the other lawyer, and man, they just couldn't do anything because they knew that Anthony got the last word. And it was great seeing the looks on their face as Anthony was kind of shoving a foot up their butt sideways. It was really fun.
Well, and I do think, Chris, kind of dovetailing on what you were talking about, I think as attorneys, so many times, we get tunnel vision on our cases, and we come to the conclusion that there's something in the case that's super important, and we fixate on it, and it's really easy to do that, especially, when you're litigating a case for 3, 4, 5 years. And boy, it's really nice to have a group of, we have a great group of attorneys at Page Law that we work with, and that we can just sit down and say, hey, is this as important as I think it is? And, but the nice thing is also having the humility just to understand that sometimes the thing that you think might be most important in your case, no one cares about. And then, and being able to pivot like that, because, I've certainly worked with many lawyers that just don't have that level of humility and think they know everything. And boy, that a lot of times that equals a really bad result. And so, Chris is certainly, we've worked together several times. Was this the third case that we tried together, Chris? Or
I
the
think
second one?
it's the second. Dan Mann, was it Dan
Yeah.
Mann? This one, yeah.
Yes. Yeah, so we've tried 2 cases together now, and boy, I tell you, I think we got a great result in this case. But if some attorney were to call me and say, "Hey, should you take medical malpractice cases in St. Charles, Missouri?" I'd probably say no. You know, to be honest, I mean, it's just, you have so many hills to climb, and like Chris said, I mean, I thought we did a really nice job of pushing the dominoes over, but the defense really set it up for us, I think, in a lot of ways. And so, but it
Yeah,
was it was
Brendan,
it,
let me give you some context. So we keep talking about St. Charles County and how tough a venue it is. So, you know, you asked at that one case we were talking about, Blair County, right?
Yep.
St. Charles and Blair County are pretty similar. I would call it rural, okay? Very conservative, very religious. in terms of the folks that, they're God-fearing folks, and probably you have a good mix of Catholics, Baptists, Methodists, whatever. Same thing with St. Charles. When just to give you, when Republican presidential candidates come to Missouri, they come to one of three places: St. Charles County, Greene County, Cape Girardeau County, and Boone County. Or four places. And so that should tell you a little bit about what that venue is. And there aren't a lot of plaintiffs' med mal verdicts that come out of that venue. Plaintiffs' verdicts in general, but med mal verdicts in particular. And so it's a tough venue. So Anthony was right about that.
Yeah, I mean, the takeaway too is, you have to just be that much more judicious in the type of case that you would ever consider taking. Like, I literally, before we got on, I was, I'm going to be filing a case in a very conservative, county outside of Pittsburgh, about an hour and a half from here. And boy, it's just, I don't think I've ever heard of anybody getting a verdict there. And I've lost a trial in this county before, and this is, to me, a slam dunk case. But just for instance, the patient was older, and I'm like, that in and of itself might not be enough. So it's just crazy when you see how bad the care was, admitted fault in the medical record, and you're still thinking to yourself, this is going to be a grind. We could lose this case,
For sure.
even despite all this. But I liked the idea of us starting with the end in mind, and we're talking about the rebuttal closing to start. But can one of you give us a little, because it's a really interesting case that you guys tried.
Sure.
So can you summarize for the listeners, what this case was about? And I will also make the point, as was the case with you guys, that I totally agree with the team approach to trying cases, in particular medical negligence cases, but all cases. And number two, I think, like you guys did, I think there's a great benefit in having the one lawyer who's kind of worked the case up the whole way, and the second, trial lawyer coming in, close in time, because they have a different perspective. They have a fresh perspective. They're going to help you, unsee some of the stuff that you're maybe fixated on that is counterproductive, and help you kind of see the big picture. I can think of so many instances in which either I jumped in late with my partner, Greg, or vice versa. And that same, and there was almost even, arguments at times, when you're
Yeah.
like, dude, like, the case is about this. I'm telling you, you have to forget about that one thing that you keep fixating on. And, but it's so important.
We fixate on things that others don't
Could you
care
imagine?
about. I've never heard that before.
We think we're right. We think we know everything.
Particularly when I was literally litigating that case for 10 years.
Yeah.
10 years. And Anthony really, I agree with you so wholeheartedly on that with Brendan. So I'm super thankful for Anthony. So let me tell the case. I mean, our bumper sticker was, surgeons must confirm before they cut. Very simple. It took a little while to get there, but Anthony was instrumental. And the other lawyer, we do a round table with cases like this where we have all the attorneys, and we almost do it like an old, Philip Miller or Rodney Jew case planning session, where we go around and we just spitball, and the first things we talk about are the rules, and we try to figure out the rules based on the facts. And then we come up with the bumper sticker after that. And that was our bumper sticker. And our rules were, surgeons must confirm the diagnosis before removing a patient's body part. That's one. That was the one rule. And the second rule is, surgeons must give patients accurate and complete information. I mean, who's going to disagree with either of those? And I will tell you honestly, their expert surgeon, every one of their experts agreed with those. Like, we in our crosses of them, we put our rules up, just two of them, and said, do you agree with these? And everybody, including the defendant doctor, and we had to preface it, as a factual question. Do you agree with these in general? Yes. And so they agree. Those were the guideposts. And so with those kind of rules in play, really the case was about a doctor who was very concerned that a mass above our patient's left breast that was in her chest about right here was cancer, based solely on what the x-rays and the imaging was showing. Okay. She got one biopsy, and unfortunately that biopsy was inconclusive, and the pathologists were telling her, you need to get more tissue to definitively diagnose what this thing is. And she unfortunately didn't get a second biopsy, and she quite frankly concluded, even before she had our her informed consent meeting discussion on October 10th with our client, that she was going to do a mastectomy. And then what she then tried to do once a lawsuit was filed is reverse engineer telling what the records mean and what she was thinking. And oh no, I disclosed with her that I recommended both a mastectomy or a lumpectomy. She could do either. Yet there was no documentation of that anywhere in a record. What she said was discussed mastectomy, and that's it. And the day before, she had sent a letter to the primary care doctor who had referred the patient over. She dictated it the day before, saying two things that were false. One, that the pathologists had ruled out fibromatosis, which they hadn't. And secondly, that after discussion with an oncologist, the decision was made to do a mastectomy. This was all before the day before she had ever even talked with the client about the surgical options. And so, also that same day she had the informed consent discussion, she actually, in her own handwriting, sent the scheduling sheet over to the hospital, and it said, diagnosis, left breast cancer. And so what we really kind of showed was that this doctor had already made up her mind she was going to do a mastectomy, when all of the experts, including their own, and she admitted it, said, imaging can make benign things look scary. Okay. Benign things can look scary on imaging. And that's why the standard of care never allows you to diagnose something, a mass, based on imaging alone. You can't do it. And so, the fact of the matter was, she was relying on, she made a decent appearance. She didn't look like an ogre. She wasn't overbearing, obnoxious, arrogant, like a lot of doctors and surgeons come across sometimes. She wasn't. She was very soft spoken. I thought she would be very believable to a jury. And quite frankly, once we kind of got done showing all the inconsistencies with the documentation, and then once Anthony Cross, they had actually 3 retained experts. We only had 1. And I did that on purpose because I think we just got to do our cases quicker, simpler, more streamlined than they do. Because if we start going into second weeks in jury trials, it's almost always in Medmalin, Missouri, the kiss of death. Okay. And so I had 2 general surgeon, breast surgeon on the case. And ultimately I withdrew 1 so that we would only have 1. And he was actually a local guy from across the river named Doug Ash. And he was just a phenomenal expert. But really, then Anthony really killed their other they had 1 general surgery breast surgeon expert from Kansas City, who I think was not very good. And then they also had 2 other experts. One was a radiologist who we did think made a good appearance, who Anthony basically turned her kind of into our expert and actually proved what we were saying on a couple of issues. And then they had this pathologist expert from Nashville who was retired and, among other things, had been sued by Vanderbilt for basically stealing $250,000 from them because she didn't keep her word with her contract with them. And Anthony really cross-examined them both, and it's totally different though. I mean, the radiologist, he was so nice to her, so got her to give us things that she probably didn't really want to give, but she did because she's honest. But then he flipped, and we saw he was good. He was good cop Anthony with the radiologist, and then he was bad cop Anthony with the pathologist and kind of, shown a spotlight on her and her misdeeds and her relationship with her hospital, with Vanderbilt, and that she couldn't be trusted to keep her word. And it kind of fit into our theme that they're asking you to trust her about what she said when she didn't document it. She said all these different things in other records, but they're asking you to trust her. And they bring these people that aren't trustworthy to come and testify for them. And so it really was about a doctor who didn't confirm before she cut. And, when that happens, you know, like Anthony said, if you mess up, you should fess up. And she just could not fess up and could not admit that she made a mistake and just wouldn't. And it was consistent with how they approached the whole case. They never once, she never once gave consent, even during the course of the trial when the jury came back in deliberations and asked the question of the jury or the court, are we capped at what we can award the plaintiff? And the defense attorney, I mean, we all heard him. He went over to the doctor and said, "That's not good. You need to come out and give me consent to settle this case." And she said no, flat out no, and walked out of the courtroom.
Wow.
And so, 30 minutes later, the jury came back, gave us 600,000 more than we asked for. And I'm firmly believe this. Juries only do that stuff like that when they are pissed. Okay. Who gives plaintiffs lawyers like me more than we asked for, right? And I think they did it because I don't think they trusted her. I don't think they trusted the defense attorney. I don't think they trusted their experts. And Anthony really brought that home in the two experts crosses and then in his rebuttal closing argument. And so
Well, it was crossing those experts was really a lot of fun. I gotta tell you. So, first of all, I love crossing defense experts. It's like one of my favorite things to do. But I do think, like Chris said, the case was about, of course, not confirming a diagnosis, but then also just overtly telling the patient she absolutely has cancer. I mean, she told her client, "You 100% have cancer. Their only option is a mastectomy." Both of those things were lies. And when she uttered those words to our client, she knew she was lying. And to us, that was unbelievable. Well, she either knew she was lying or she was so incompetent that she didn't realize that she was giving her inaccurate information. Either one of those things is absolutely horrific. But the defense set out in the case, and the defense attorney really did us a huge favor in opening statement. He made the case a one issue case. He told the jury, if you believe our side, you have to, find in our favor. Because, but if you think we're lying and you believe them, you should find in their favor. And boy, you bet we brought that up in closing, because not only was there the lies in the medical record and then the letter that she wrote to the doctor and then in her testimony, they brought in an expert, the one expert that we were really hard on, that had stolen $250,000 from the university where she worked. And it's like, and in closing, it's like, these folks ask you to trust them. And they brought in someone who stole $250,000 from Vanderbilt University, and they're saying they're the side with integrity. I mean, that doesn't make sense. And in fact, Chris alluded to it earlier. Chris had made a math error when he filled out the jury verdict. And in his part of the closing, he put
Yeah, I have a blow up. I have a blow up
big
of the
blow
verdict
up.
form,
Yeah.
and I write in plaintiff, and then I wrote the numbers because we
Yes.
were only we only submitted past non-economic damages and future non-economic, because the medical bills for all of her reconstruction surgery, because she got a bad infection following the mastectomy and had to have 5 reconstruction surgeries.
Oh,
It was
geez.
only like 25 grand. Medicaid paid
Yeah.
25
Yeah,
grand.
you're not going to put that in.
No, and
No.
I'm adding the 2 line items, and it was 440 and 450. So I was really wanting to ask for 890, and what I said was 990.
Yeah.
And I go sit down, and my client, who quite frankly we should talk about, Anthony did a great job putting her and her sister on the stand. That's another side kudos to him. But Kimberly, who is, she may have some issues in terms of she's got bipolar disorder, and there may be some issues of understanding that were clear in the case and the jury picked up on. And she kind of nudged me, poked me, and she said, "Chris, your math's not mathing."
Well, you carried one too many
And
ones.
she
Yeah.
goes, it adds up to 890, but you asked for 990. And I looked at Anthony and I said, "Hey, you've got to bring that up. You've got to make fun of me in your part about that." And I got to tell you, dude, tell him, Anthony, it was perfect. It was just,
Well,
Anthony just handled it perfectly.
when we got and we were talking about the lies, I said, just I pointed to his I left the big blow up while I was talking, and I said, folks, just like Chris writes math, that just don't add up. And they all started laughing. In fact, one of the jurors asked us after the case if we had set that up intentionally, and I said,
Oh,
"No,
right.
I wish we would have." It's like,
Oh, yeah.
but
Yeah.
it's just all about, I mean, I think the other part of trial is just being in the moment and paying attention to what's going on instead of worrying about, hey, what's the next scripted thing that we need to do. But I really think that it was the seven. We really identified seven big lies in the case, and even in addition to all the lies that were told in the record and to our clients, I really thought the jury needed to understand the manipulation that had been that the defense had tried to pull on them during the trial. And one was bringing that expert in that had no integrity or credibility at all. And I had a hard time understanding why you were doing that. But then you have the expert Chris talked about, who is this a radiologist, a very sweet lady, very nice. And I mean, the jury got to hear how she had goats and pigs and lived on a farm, and like, she just came across a very genuine person. Well, as we started walking through her testimony, it became clear to me that she had no idea what the defense was trying to use her testimony to do.
Mm.
And they were trying to use her testimony to say that our client lied about where the lump was. And the lump was up here by her collarbone versus down here in the breast. And they were trying to say that they were trying to use her testimony to prove, but she didn't know that. I mean, the expert didn't know that. And so at the end of her testimony, I said, I started asking, I'm like, are you aware that these folks are trying to use your testimony to say that our client was deceptive or lied about where the lump was? She said, no, I didn't know that. I was like, well, let me ask you. So we had this picture that our client had drawn a circle around where the lump was. And I said, if our client said that's where the lump was, is that true? And she goes, yeah, absolutely true. She goes, and I said, it's not deceptive. No, it's not deceptive. That's not even wrong, right? You actually agree with that, right? And so in closing, we got to bring and say they tried to put this nice young doctor in front of you, and they tricked her. They tricked her too. They brought her in here and had her give this testimony, and then they tried to use her testimony to pull the wool over your eyes, and she didn't even realize that she was complicit in their deception. And I thought that went over pretty well because the jury really liked her. You could tell. I mean, they were all setting forward and taking notes. And I thought when we were able to turn her, that was a pivotal moment too.
Yeah.
Brendan, can you see this?
Yeah. Yeah.
So this is the history in physical form that our client, that the defendant filled out for our client the very first day she saw her. And this is the handwriting where this is what the doctor wrote where the mass was, right?
Mm.
And they kept trying to tell our jury and us that actually it was in the breast. They kept saying it's in her breast tissue, like here. And the radiologist actually was showing the image. She was trying to suggest why the imaging shows it's actually in the breast, the meat of the breast tissue. I don't know any way to say it other than that.
Yeah.
Well, so Anthony, was showing her exhibit of the actual imaging, and it was actually of the ultrasound imaging, trying to show, well, it's in the breast. Well, down here, and it's not this, but down here at the bottom left of the screen on her image of the imaging, it showed like a torso, a chest like this. And it had where the ultrasound probe was, and it was like right here, same spot where this is, right? So, but the defense didn't ask her about that, didn't pull it up, nothing. in their direct of her. Well, Anthony had the IT guy pull that little tiny torso up at the bottom left of her exhibit and blow it up and then put it right next to the one I just showed you.
Mm.
And I mean, you could see the defense lawyers were like, they're like, doing this. And Anthony said, so you agree that where the probe was for this image showing the lump is exactly where our client told Dr. Yeager it was, and Dr. Yeager, and she goes, oh yeah, that's the same place. And I mean, that completely destroyed. I mean, they were trying to put fear in the jury that this was breast cancer, right? And it's in the breast. It's not, it's in the breast tissue, and that makes it very, very scary. Okay, this is a very bad thing. And Anthony got that very nice, very credible defense expert to basically show that Dr. Yeager and her other expert were lying about that it was in the breast tissue. And so he just did. And I wish you could have seen how he handled her versus the other gal, the older retired pathologist that stole 250 grand. It was just masterful.
What I'm hearing from you guys kind of goes back to a point you made at the very beginning, Chris, about, in med mal, you have to learn the medicine, inside and out. And sometimes there can be a curse of knowledge because, we sort of forget that the jury does not have, that level of knowledge. You get into the weeds and it can cause problems for the case. And you said, despite the fact that you've got to learn the medicine inside and out, that generally speaking, as kind of a rule of thumb, you typically don't want to fight the doctor on the medicine. And everything you guys are talking about, it's obviously it all has to do with the medical aspect of this case, but it's bigger picture issues. It's telling the truth, it's misrepresenting, it's inaccuracies, and that seemed to be what the overall. And you had your rules, you had your bumper sticker, people get it, but probably what moves the needle the most are, sort of we'll call it like the medicine adjacent issues, the
Yeah,
bigger picture issues in the case.
for sure. And I will tell you, Anthony, we did not understand why, because the pathology expert they had come in and the radiology expert, they were basically saying the same things that the treating pathologists and radiologists were saying in the records, And so Anthony was like, why are they calling these two? What are they doing? And ultimately what they did is what they really tried to do with the pathologist was their breast surgeon expert would not admit or say, and that's what they were wanting her to say, was that she was going to need a mastectomy anyway. Even if they tried a lumpectomy, because it was so large and where it was located, they were going to have to ultimately do a mastectomy. That's what they wanted their breast surgeon to say, and she wouldn't say it. She couldn't say it. She actually said in her deposition, oh no, I think either one would have been appropriate, and I can't say if she would have needed a mastectomy anyway if a lumpectomy had only been done. And our expert said clearly no. And he explained it actually he did an easel and drew why a mastectomy was actually the worst possible approach to try and remove the lump, because you couldn't get clear margins by doing a mastectomy. And that the only way to really get clear margins of this lump is by doing a lumpectomy, where a lumpectomy, you're basically going at it like a target. Whereas a mastectomy, you're removing the breast and then coming at it from the side. And he actually drew that out, explained it to the jury, and their expert would not go as far as they wanted her to go. And so they got this pathologist to do it, who had never done a surgery like this. But she said, because I consult with breast surgeons, I can say that a mastectomy would have been needed.
Yeah, pathologists are often called
Right.
on to
Even
to
though
do
the
that.
radiologist, Anthony got the radiologist to admit, I would never tell a surgeon what to do or what's going to work. Even though she had general surgery residency experience, she said, I would never tell a surgeon what surgery to do or what surgery is going to work or not work. That's their decision. And so I think they brought the pathologist because she was willing to
Yep.
go and say that, and they had nobody else willing to say that.
Well, and by the time we dropped the credibility bomb about her stealing money from a university and, having and her lying about it, initially, because, the way we approached that was to kind of build it up to a crescendo a little bit. And so when so I went over and, as I started, I said, "Doctor, thanks for your time today. You understand I have to ask you some difficult questions." And, so I kind of walked over by the jury, so she had to look at all of them, and I said, "Do you want to tell all these people why you were fired by Vanderbilt University?" And she said, "We had a disagreement." And I said, "Doctor, you know, yeah, listen, I'm like, either you're gonna tell them or I'm gonna have to tell them." I was like, "How do you want this to go?" And she goes, "Well, they said something about me taking business and money." And I'm like, "Doctor, do I have to get the court records out before you'll level with these people and tell them what happened?" And not only was she did she steal, she then used the court process. She went back and sued the university for discrimination, and that case was dismissed on summary judgment. And so it just made her look very bad. And so kind of we went through all of the testimony, but then one of the guys I started trying criminal cases when I first came out of law school, and there was a guy here in St. Louis named Brad Kessler that was I second chaired 5 murder cases with him when I was in a law school. And he always told me, he said, if someone uses an exhibit, he said, you figure out every way that you could use that exhibit against them. And as I was sitting there during the direct, the defense attorney had brought in this doctor's book that she wrote on pathology and about specifically like breast cancer pathology and fibromatosis. It actually had 2 chapters on fibromatosis. And so while they were finishing the direct, I asked his associate, I'm like, "Hey, let me see that book." So I got the book, and I had not seen the book before the trial, but I just looked in the index to see if there was mastectomy or breast removal surgery or anything in the book. And so we got, part of her cross was me taking that book, marking it an exhibit, and I handed it to her and I say, "Show me one place in this book that you wrote that it says you treat fibromatosis with a mastectomy." And she couldn't show it because it wasn't there, because it isn't true. But I
Yeah.
thought it was and I even opened to the chapters and I said, "You wrote 2 whole chapters on fibromatosis in this book and not one mention that you do a mastectomy." And she had to admit that that was the case. But by that time we had already kind of taken her credibility down to 0. And I think that was just kind of hitting the point home. But I think I'm sorry. I'm at home today, Brendan, because we had a babysitter cancel. So if that's all the noise and kids and dogs,
All
um,
good, man.
but at the same, but once we destroyed her credibility, it was, the jury just disregarded, I think, everything that she said. But even when you have those credibility issues, you still have to push home your case. And one thing I thought at the book into all of that when Chris did his close was bringing it all back to our expert, Dr. Ash, and everything that he said, and what a wonderfully credible and just nice man that he was. And you put together that dichotomy, and all of a sudden the jury is on our side when normally maybe they wouldn't be. So it was just a nice way that it all played out.
Yeah, I mean, they really Brendan, and I don't we don't want to. And Jim Reiner and Jeff Atkinson, who defended this case, they are. You think of the top med mal defense attorneys you run into all the time in Pittsburgh. That's these guys. All right, they defend and try so many cases. Quite frankly, I just think they're used to winning.
Yeah. Right.
And they're really good. And I mean, I've tried 4 cases, med mal cases against Jim Reiner. This is my first win. And so they're really good, but they really fed into this to really were our theme, because they were attacking like our expert, for example, Doug Ash. He is one of the best experts I've ever seen. And he does 50-50 plaintiff defense in terms of reviewing cases, 60-40 defense in terms of testimony at trial, 60-40 on behalf of plaintiff when it comes to depo testimony. And that all kind of makes sense if you know how these cases work. And he also, significant part of his practice of general surgery is breast surgery. It's actually very similar to the defendants, but they tried to suggest right away in their opening that Dr. Ash was not a breast surgeon. And so, I showed him his CV. He told him that, large percentage of his practice is breast surgery. He's one of the only two general surgeons in Illinois on that side of the river that actually does biopsies. That's a surgeon, because most of the time on the Missouri side, radiologists do the biopsies. Okay. But he's one of two surgeons in that whole community where he practices, where he is doing biopsies. He's been doing that certified since 1995. And so but that was one of the first things they said about him in their opening was he's not a breast surgeon. Like, we're lying about his expertise. And, I asked their breast surgeon on her cross, what were you doing in 1995, doctor? She was a sophomore in high school. And I said, so when you're a sophomore in high school, Dr. Ash was certified as a breast biopsy provider and has been doing it since then. I said, is there any doubt that you were here for his testimony that he's a breast surgeon as part of it? And she fought me on it. She would not agree to it. And I think it's those kinds of things that added up to, you can't trust them. They didn't have to lie about, they didn't have to do that. They didn't have to do any of that. They could have attacked him on other ways and they didn't. And, then there was the issue of, so the defendant doctor, she'd been sued 5 times in addition to our case for medical malpractice. And there's some law in Missouri that says if you put the defendant on and ask them expert opinions, as opposed to just ask them what happened, what'd you do, that type of stuff, and it's a very recent case, and it was actually Jim Reinert was on the other side of it, where the court said, when you do that, you are opening that expert up, or that defendant up, to all the ways that plaintiff lawyers like Anthony and I can cross-examine them: bias, interest, credibility, all that stuff. And so they filed a motion to eliminate to keep us from asking that stuff of her. And the judge, really kind of surprisingly, because we're always so used to getting these kinds of rulings going against us in med mal cases, because they just almost always give the benefit of the doubt to the defendants, even when the case law is clear that they shouldn't. The judge actually, we argued it on a Thursday before trial, and he said, listen, I'm gonna read the cases. They submitted their cases to him. Anthony submitted our cases to him. And by gosh, we showed up Monday morning expecting, we had already prepared. We weren't even sure what we were going to do, to be honest with you, on that issue, if they were, but if they allowed us to. But we thought for sure he was going to say, you can't do it. Well, Monday morning, we go on the record, and he says, listen, my gut says I shouldn't want to do it because it's prejudicial to the defendant. But Jim, as soon as you ask her an opinion, expert opinion, I think you open it up. And so he denied their motion to eliminate. But as we're walking back to the tables, I said, so what are you going to do? Oh, he said, I'm going to ask her the question. I got to ask, because he has to have her say, I met the standard of care. I didn't reach the standard. You don't. I had plenty of cases where the experts, their retained experts, said that, and the doctor just, said, I did what I felt was appropriate. That's not an expert opinion. He could have done that, but he didn't. And it's because I think she was just so heavily invested and involved and just could not admit that she did anything wrong. She had to say, I didn't breach the standard of care. And by God, he did. We were like, what are we going to do? What are we going to do? And what's he going to do? And on her direct, he opened the door to it. He said, he raised his 4 fingers up and said, now, doctor, it's true. You've actually, unfortunately, been sued 4 other times for medical malpractice and besides this case. And can you walk the jury through those cases? And what happened? Well, nothing happened. They either got dismissed or one of them was tried to a defense verdict.
Yeah.
But we had done some digging and actually found there were 5 cases, not 4. And she also had not disclosed that case in her interrogatory answers. And so as soon as he held up 4 fingers and said that, I remember kind of nudging Anthony and saying, did he really just say 4? He didn't say 5, right? Just said 4. And so I wasn't going to go into the particulars of the cases. I just hammered her on the fact she just not only did she lie in her interrogatory answers, I said, you just lied to the jury under oath right here with Mr. Reiner. You told them you only had 4 cases. And in fact, the most recent case you've been sued on for medical malpractice was this one in the city of St. Louis that you didn't tell us about. And all she kept doing was saying, well, we looked it up. We looked it up. We looked them up. Because you can look up Missouri CaseNet and find out how many, times somebody's been sued. And I said, doctor, I'm not talking about you looking up CaseNet. I'm saying times where you've been sued for medical malpractice and you just told this jury you've only been sued 4 times when in fact you've been sued 5 times and it's the most recent case.
And no one believes that. Well, at least I don't think anyone on a normal jury would believe that you could be sued and not remember.
Yeah,
I
no,
just have a hard
absolutely not.
time thinking that people will believe that. And I don't know, it would be an interesting question for the people on the jury. It's like, how big of a deal would that have been standing alone, like if we didn't have all of these other lies that were told? But it's certainly, I mean, because even by that time, I think the jury was really questioning her credibility with the issues with the letter and the medical records, and her lawyers telling them, well, don't believe what she wrote in the record, believe what she says here in the trial, which was just like, boy, that's so we did have a lot of good lies that got
Yeah,
away.
I mean, I think in that scenario, it's interesting in the sense like if most of the prior instances that had been dismissed, or it was a defense verdict, could that come off as just like, oh, here's another doctor getting frivolously sued too much? On the other hand, one of the biggest things that juries are always asking about in focus groups and so forth are, prior acts, prior instances, whether it's on the defense or the plaintiff,
Yeah.
all that kind of stuff. And so, in your situation, I just think the killer then is like, then why are you hiding the fifth? And to Anthony's point, nobody's going to believe a doctor doesn't remember, or you get sued that much you can't even keep track of it anymore. I mean, it definitely does not doesn't look
Well,
good.
well, and I think
Well, that's what we were
we're all
afraid of.
kind of taught to like try the lie, as
Oh
sort,
yeah, totally.
but I think one of my another guy that had been a mentor to me for years was a guy in St. Louis named Matt Padberg, and he used to say, well, try the lie if it matters. And what he meant by that
Yeah.
was, if it's a mistake that you could kind of wrap your head around like a normal person making, hey, you checked the wrong box on a form or something, that's one thing. But if it's something someone should remember and they're trying to hide the ball because they want to make themselves look better, which is certainly the lawsuit thing seemed to do, yeah, then I think you just hammer them. And Chris did a great job doing that. And we were both kind of like, man, how many gifts are they going to give us here? But I mean, at the same time, we got a lot of it, but I thought we did an effective job of really driving a truck through it too. Once
So
they
yeah,
gave,
Well,
two
but Brendan, you brought up the biggest concern I had was if he doesn't, if he didn't bring it up in direct, how was I going to bring it up in cross the prior lawsuits so that it didn't look like what you said? I was concerned the jury would make it would look like poor Dr. Yeager. She's been sued all these times that from these frivolous lawsuits and these dang plaintiffs who are, and they didn't go anywhere. I mean, honestly, I wasn't sure if I was going to even ask her about
yeah.
those things because I was concerned about that. And I think we're right to be concerned about that because you know how it is. I mean, the lawsuit lottery thoughts and these poor doctors and
Yeah.
my doctors get, if they get sued too much from frivolous stuff, they're going to leave, right? And I'm not going to have a doctor. And so, quite honestly, I, right until he was done, until he held up his fingers and said 4 and went into it, I was not going to really ask her about any of those lawsuits because I just didn't know how it would come off to a jury. And if I thought we had them by that point. I thought we had a majority of the jurors with us, and I didn't want them to then. I didn't want to go on code and be, the plaintiff lawyer who's hammering her over these frivolous lawsuits that didn't go anywhere. And
Yeah.
the once he did that, I didn't make it about the lawsuits. I made it about that she just lied about the lawsuits. And in fact, the lawsuit she lied about was actually one where the lawyers who were sitting at that table, who were defending her in this case, actually represented her and filed an, and I had the answer. I had both the petition and the answer. And when she kept kind of, we looked it up. We looked it up. She's kind of like blaming it on the lawyers. I said, no, no. They're not the ones on the stand who just told this jury you only been sued 4 times. You're the one under oath. And that's, I will tell you this here. You asked for tidbits or nuggets. Anthony gave me this nugget in trial, and I actually used it with the defendant doctor because she was so soft spoken, really so kind of nice looking. The way he approached the pathologist, he just right off the bat, he asked her, you understand you're here being an expert, you're giving expert testimony. You understand that I, representing Miss Kennedy, I have to ask you very tough questions. Do I have, and he basically asked her for permission to do his job to ask her tough questions. And what's she going to say? No, she said yes. And so I stole that with Dr. Yeager because she was very soft spoken in her direct. I was scared to death the whole trial that and I'm a pretty bulldog dude. And if I did that with her, it was going to be a mistake. So I really, so that was the first thing I asked her is I said, I don't want to be here asking you these questions, but we are. I have to represent Miss Kennedy. You understand that you have put your credibility squarely at issue by what you're saying happened in this visit when it's not documented. So you understand that your credibility is clearly at issue. Yes. I have to ask you really hard, tough questions, and I will do my best to do them respectfully. Do I have your permission to ask you those tough questions today? And she looked at the jury and said yes. And I will tell you the one thing that Jim Reinert, and he's a great lawyer, said to me during deliberations when we were talking, he said what Anthony did with her and what I did with his doctor, doing that at the outset was genius. That was the quote. That's what Jim Reinert said. That was, quote, genius, because you didn't look like an asshole who was just attacking her. You look like you didn't want to be doing it, but you just have to do it because it's your job. And I said, Jim, that's Anthony. Anthony gave me that. I've been doing this, watching really good lawyers for 28 years. And that was the first time I'd ever seen that. And I was like, holy crap, that worked. I'm going to try that with Yeager. And it was great. So
That's awesome.
That's a nugget that I would really suggest to lawyers try and use. Is it's like what we do with jurors in voir dire, right? We ask them for permission for certain things. Like when we don't want our client there every day, we tell them they're not going to be there. And do we have your permission to do that, or is anybody going to hold that against her, right? So now what's the witness going to do when you ask them permission to just do your job and represent your client and ask you tough questions? Are they going to say no? No, you can't do that.
Yeah. No, I think that's a really classy approach. And I think that's something I think sometimes I think maybe we've inadvertently done that in a couple of situations, but it's like you should do that always because that is just such a better natural start, and it kind of, I think, normalizes the situation and helps the jury understand that, look, you're doing your job, and part of your job is, zealously advocating and maybe being a little tough on this witness because you're doing it for your client.
Yeah.
Now, we've covered a lot of territory. I'd like to wrap up by you guys just telling me, how did you approach, you're given all these gifts. A lot of it, just seems like a situation where, this doctor just couldn't fess up and, just leads to all of these different, gifts for you guys and, landmines for the defense. How did you approach presenting your client and her story, juxtaposed with all of this in a way that, was going to resonate, or not backfire in some sense?
Well, and Brendan, I'll tell you the story here, and like I said, I apologize if there's any background
No,
noise
you're
from
good.
all these little kids. But in I took the same approach with our client. Our client had some mental health issues, had some communication issues, had a stutter that was pretty serious, especially when she would get nervous. Our client was scared to death to get up in front of a group of people and talk about this. And I mean, even in the best case scenario, you can't imagine like, anyone wanting to get up and talk about this and having to show pictures of mutilated breasts and stuff like that to a jury, to a bunch of people that they don't know. And so we really had to do a lot of work with her. It was just hours of us talking to her and making sure that she was ready to go. But I think, and then we also had her sister that was part of the treatment and also helps kind of navigate through a lot of things in her life. Not really, she wasn't like formally like appointed as a caretaker or anything, but was just, her sister helps her do a lot of things. So we had her sister testify first. And we had her explain to the jury the difficulties that our client has with communication and things like that. Also, how that we were really worried about our client getting on the stand and getting really angry because she had before with us in preparation. And so I tried to diffuse that with her sister. I said, she's obviously very upset about this. I said, is she angry? Yeah, she's angry. Tell me why she's angry. Well, this, the little bit of life that she thought she had, like romantically and privately, now she thinks that that's completely gone. Someone who's had all of these difficulties already because of the conditions she already did have. Now she feels like, and what she said on the stand was, it makes me feel like a monster. And, when we were, but in going through and trying to figure out like, hey, how to tell her real story to the jury, I think it's all, and I think, this isn't anything that you all haven't heard before, but it's telling about the pain and suffering through stories, and I always like to have the client kind of get a story from each different aspect of life that I think people on the jury will relate to. One from private at home, one a thing that happened at work, one thing that happened around the holidays, and then one thing that's like a more intimate thing, with like like an intimate relationship. And her stories were just gut wrenching. And she had this one instance where she was working at the baseball stadium downtown, and the prosthetic breast that she had to wear after all this, it fell out onto the grill in front of her fellow employees. And her talking about how embarrassing that was, and then, like, she had an issue at home where, like, her dog got a hold of it and ran out the door in front of all of her neighbors, and just, like, this level of, like, embarrassment and fear about going out in the world, and, I mean, like, the jury could really feel it. I mean, and you could tell, and we had a and thing is one of the reasons we had such a great result is Chris did such a wonderful job in Voir Dire. We ended up with 7 women on the jury, and I felt like all of them, you could just tell were just related to her so much. And those issues that we thought were gonna be big issues, like her stutter and her mental health issues, they endeared her to the jury. Those folks thought that this woman, one of the people even said it during Voir Dire. They said, "I can't believe how courageous that this lady is to come in here and do this," and that's what we ended the whole trial with, was the word courage written up on the screen really big. But, I think the jury and then again, the defense kind of stepped in it, man. They like, all this is going on, and I mean, I think anybody who was watching knew that, like, these folks really seemed to be relating to this lady very well, and then the defense attorney got up and attacked her
Mm.
and just was not reading the room, and something that, and like, this kind of a little off topic, but something that I've never had happen before in a trial, and it was the defense attorney got up and tried to insinuate her sister was lying because at one point in time they had shared a checking account because she was helping her pay her bills and learn how to do things, manage money, because she does have mental health issues. They don't have one anymore, and didn't for, 5 years before the trial. It kind of made me upset, and I did something that more out of anger, I think, than real thought process, because I always believe that if you're gonna call someone a liar, just call them a liar and don't beat around the bush, be a man and stand up and say what you think. And I got up and redirect, and I go, and our client's sister, I said, "Did you understand what he was just trying to insinuate about you?" And she goes, "No." And I go, "He was just trying to say that you're doing this for money. That's why he was at why did you hear when he asked you about your checking account and everything? That's why he was doing that. He was trying to get these folks to believe you're doing this for money. Do you stand to gain anything financially from this?" And she said, "No." The defense attorney got up and apologized to her.
Yeah, in his redirect, that's
It's
what he did. He got
Yeah,
up and
he got up and apologized. He said, "I'm so sorry, that wasn't my intention." It was, but he said it wasn't his intention. I never seen that happen, but,
which
you know,
which
just
only
as
highlights it, which
yeah.
only highlights it again. And Anthony, I think, said something about that in his rebuttal cross.
But here's the thing that I've been telling people for, and I like I said, I didn't make that. This is all just some of this is from like The Edge, and Trial by Human. It's just like
Sure.
things that you kind of wrap your arms around. But the importance of having your clients write this stuff down. And, so we always have the clients fill out a form before they're about to testify, where they write down, what are the 10 ways that your life has changed? Give us specific stories that illustrate it, what are the 5 fundamental truths of this case? And even with someone that was challenging and that had some mental health issues, what you see is during cross-examination is they write it down. Something happens in their brain that I'm not smart enough to explain, but something happens, and even our client in this case, when in cross-examination, when she was testifying, when she felt stressed, and you could tell like they were kind of getting on her nerves a little bit, she reverted back to the things that she wrote down before the trial and have him write it down more than once. I had to write it down a couple of different times. It just commits it, and then when the nerves come, it's like, okay, well, and it's almost I don't know, it's almost like a miraculous thing because I so Chris, I always have those things, I have those stories, so I don't forget to ask about them in direct. And I even showed one of our paralegals that I was like, she said it almost word for word as she had written it down while she was on the stand. And it's like, I just think it's real powerful because one, it's in their own words. So we're never telling people what to say. But two, like when on in that cross examination where they're kind of in the arena with the other attorney, and you have to step out of the way and can no longer be the protector, or they've got that shield. If they've gone through that process, I've just noticed it really over the years, last 16 years of trying cases. I've noticed that helps a lot.
That's awesome.
I
So
do.
you guys have like a set form that then, you have them, kind of homework. Like you got to sit down,
Yeah,
you got to
Anthony.
write out
We
your
really call it
stories and
homework too.
yeah,
We
Yeah,
that's
it's
Yep.
great.
it's it's Anthony's form. It's great, and Anthony. Thank God for him because he spent literally what probably 7 hours with those two witnesses for maybe a grand. I mean, I think our client was on the stand direct 15 minutes maybe,
Yeah.
and
Well,
her sister was on maybe 20. But we were very fortunate. A lot of times you'll have these he said, she said cases about what's not in the records, and it's only doctor versus our client, Kimberly. Well, thankfully, her sister was actually at the informed consent meeting that happened 3 days before the surgery. And she was just a really credible person.
Yep.
Okay. She's a paralegal. She's been a paralegal at different law firms. She's a paralegal at a family law firm in Texas right now. Her husband is a U.S. Air Force person. And she just was, and Anthony just did a great job preparing them short, simple, sweet in their own words. And they just looked credible. It didn't look rehearsed. When they were being crossed, they were just very short, simple, answered the questions. Our client did not get angry. We were both very concerned that Kim would get upset and angry. And she didn't. And I think the jury really did connect with her because I will tell you, the Friday night after the jury verdict was read, and I'm going out to my car in the parking garage, one of the jurors that we were extremely, extremely, extremely concerned about, and we could not get her off the jury. She and her husband own a physician staffing company. Okay, so they're putting physicians in employment places, but they don't. She said they didn't have any clients here in town. They're all out of St. Charles, so it wasn't involving. But I just don't believe that. I've had people on there before that actually were in a case with Jim Reiner that actually were rats, and the husband in a similar situation was a rat. And we could not get her to give us the language to get her off her cause, and we did not want to use a peremptory on her because there were people that were actually kind of clearly much worse. She came pulling up. She's in her maybe late 30s, early 40s. I'm loading stuff in the car. She comes pulling up in a brand new Mercedes G-Wagon, okay? Not what I was expecting from a St. Charles County juror, and she comes pulling up, pulls over to me, stops, rolls down her window and says, "Mr. Wright, you are going to help her with this money, right?" And I'm like, "Do you mean like investing it, putting it into a structure?" She said, "Absolutely." She goes, "Because it's clear she needs help." And so we didn't bring up a bunch of her mental health issues. We presented her, and they saw that she needed a little help. And then she then goes on, and so it was 10, we had 10 signatures out of 12 on the verdict form. She's offered without me even saying anything. I just said, "I really appreciate what you guys did." And she goes, "Well, I'm going to tell you, I didn't sign the verdict form, but the only reason I didn't sign it was because if you had only had 8, I would have signed it to give you 9, because that's what we needed to get a verdict." And she said also the other juror who didn't sign it, not because she didn't vote for the plaintiff. She thought we weren't giving plaintiff enough money.
I love that. I love
And
that.
so it was just that told me that Anthony, what he did with Virginia and our client, really kind of resonated with the jury. If it resonated with this person who owns a physician staffing company, and that was the whole reason why I tried to get her off. I said, isn't this going to be difficult for you to explain to your clients potentially if you are signing a jury form awarding a verdict against a defendant doctor? And in Verdire, I was like, "Oh, no, I'd have no problem." I didn't ask
Yeah.
her why she didn't sign it, but I knew why. She didn't sign it. One, she didn't have to, and two, she didn't want her name on a
Attached
verdict,
to
a
that. Yeah.
$1.5 million verdict, hammering a surgical group. So, but I just think that told me that what Anthony did with our client and her sister was really, and it just, how this goes. To get a verdict in a med mal case, whether it's in a great venue, what we think for us, or bad, a lot of things have to come together for us to get that. And I really do think we had two really good folks, Virginia and Kimberly, and Anthony really did a real good job putting them in front of the jury. So
Amazing. And yeah, we'll wrap with you guys. You asked for what, 850, 890,
yep,
and
I asked for 890 on the board. I and verbally asked for 990, and they gave us 1.5 million, 500,000 for past non-economic damages, and 1 million for future non-economic damages.
amazing. Your client must have been thrilled.
Anthony, was she happy?
Well, I mean, she hugged me and was sobbing uncontrollably. So
Ah,
yeah, and I mean, we had a group of paralegals there too
Yeah.
that were just really so. I mean, I can't tell you the great team environment we had there, and we had a group of paralegals that were just just bawling, and it was so nice to see something like that because they all really cared about our client and understand the difficulties that she had and stuff even outside of this case was just tremendous, and so it really so yeah, it was just a tremendous experience to be a part of.
amazing. Awesome, guys. Well, very great story, great outcome, and you guys shared a ton of really thoughtful insight and advice on things that worked in that case that I'm definitely going to apply in my next trial. So thank you for that. So that's Chris Wright and Anthony Laramore from Page Law down in St. Louis, Missouri. Find these guys. You ever need great lawyers in Missouri, and hit them up and pick their brains because clearly you guys You have a lot of great stuff to share. So thank you both for doing this.
Thanks, Brendan.
Thank you, Brendan.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.